Concern. Each week at this time, an inquiry on a selected public affairs matter by representatives of major religious communities is presented by WTCN Television. Moderator for Concern is Stuart A. Lindman, WTCN Television Director of Public Affairs.
Good morning, good morning. The program called Concern that gives to representatives of our major religious communities an opportunity to meet with persons who are knowledgeable in a specific area of community concern. And this Sunday morning, we're speaking on deregulation of radio. Deregulation of radio. And our special guest this Sunday morning is Mr. Mark Nielsen of the Church Federation of Greater Chicago. Our panelists this day are Joan Burnett, Communications Director of the Archdiocese of St. Paul, Minneapolis, Mr. David Goldman, representing the Jewish Community Relations Council, Anti-Defamation League of Minnesota and the Dakotas, and the Reverend Mr. Louis Wargo, Senior Minister at the Congregational Church of Excelsior. May I state before we start our conversation this day that since the year 1912, licenses to operate broadcast entities have been under federal supervision. At first, such supervision served the purpose of assigning frequencies and preventing interferences. The supervision is also meant to assure that the licensees use their airwaves for the common public good. The FCC has been the agency governing broadcast entities since 1934. Recently, the Federal Communications Commission proposed to ease some regulations regarding radio's operation. The FCC determines licensing of a station, and it has required broadcast operators to ascertain the needs of the communities which they serve and to devote a certain portion of their broadcast schedule to responding to those needs, providing religious, educational, political broadcasts, etc., etc. The FCC has asked stations to observe certain guidelines that limit the percentage of commercials and also to keep program logs. Well, these are some requirements that the FCC has proposed to change, to eliminate, reasoning that broadcast competition will encourage stations to deliver that which their audiences need. With that background, to our guest. Mark, what is your profession, sir?
I'm serving as communications legislation consultant for the Church Federation of Greater Chicago, and I also work for a law firm, have done work with the Illinois State Bar Association in media consulting, and other related activities with law and communications, testifying before the U.S. Congress, etc.
What's been your role in responding to the FCC's proposal, generally speaking?
Generally, I've filed comments for the Church Federation with the Federal Communications Commission. I've attended conferences and trying to promote other groups to contact the FCC with their concerns about the proposal, and generally doing such things as this, trying to get on the airwaves to tell the public that the FCC is attempting to deregulate radio and the impact that it will have on the American public.
All right, thank you, sir. Now come the tough questions. Joan, you're first, please.
Mr. Nielsen, what effect do you feel that the proposed regulations or passage of the proposed regulations would have on public service programming?
Well, there are a number of impacts. The first is that the Commission is stating that it will remove the requirements that radio broadcasters provide news, public affairs programming, and other non-entertainment type programming, and leave it to the marketplace to determine whether or not this programming will be presented. The impact, obviously, is that public service programming will decline, if not totally diminish, from the airwaves. Public service programming such as this right here, is not profitable to a station. They do not have commercials on it. They do not receive income for the program. It is rather as an obligation to serve the public interest that they present this type of programming. If I'm a radio broadcaster and I'm faced with having a public affairs program where I'm not going to receive an income, or putting on an entertainment program where I will receive an income, good business sense and economics and the marketplace tell me that I will put on entertainment programming and not have public service programming. And in fact, the Commission, the staff of the FCC, has stated in the notice that they expect public service programming to be removed from the radio airwaves.
David Goldman, please.
Mr. Nielsen, one of the areas that this proposed rulemaking deals with is ascertainment procedures. And we know that they are somewhat complicated and cumbersome, and some people criticize them because they don't seem to lead necessarily directly to programming that actually gets on the air, dealing with issues raised in the process itself. Do you have some ideas about changes that should be made short of doing away with the ascertainment process?
Okay, well, let me first explain for some of the people who may not understand. Ascertainment is the process whereby a station is required to go out into the community, to have a survey of the community, and to interview community leaders to find out what are the problems and needs of that community, and then they are to go back and do programming about those needs that have come out of the survey and contact with the community. The process, the idea of going out, finding out what are the needs of the community and programming for it, are a mandatory marketing tool. It's something that a station has to do if it is going to serve the public interest. So the concept of ascertainment is sound. Currently, there's a very strict type of process. A certain number of people must be contacted, a certain form of survey, et cetera, and you have a lot of paperwork for it, much of which is totally worthless. It's not necessary to have that much. The only reason we have it is because of a request from broadcasters and the Federal Communications Bar themselves that they wanted very explicit guidelines. The Commission originally stated you should have ascertainment, a very general type of guideline, and do it as you see fit so that you can best serve your community. Broadcasters said, no, we want it very explicit. I think that what they should do is go back and make it less explicit and cut down on the specific paperwork.
Mr. Wargo, please.
Mr. Nielsen, taking off from the ascertainment, the arguments in support of the deregulation of radio seem to indicate that the public interest will be met, will be controlled via the marketplace. Yet I was interested in some of the comments which were part of your formal filing with the FCC regarding the whole marketplace notion, and you seem to indicate that the marketplace, marketplace economics do not fit the communications model. I wondered if you'd expand on that.
Okay, let's look at exactly some of the basic changes that this proposal is doing. And they rely on marketplace and economics for these changes. They are taking the standard of public interest. Broadcasters must operate in the public interest, convenience, and necessity. The FCC is proposing to change that to say that broadcasters must serve consumer wants. Consumer wants are totally economic. They don't take into account First Amendment rights, the rights of minorities, etc., just merely consumer wants. Now we're saying that the marketplace will meet consumer wants. The basic question is, who is the consumer that the marketplace will serve? In broadcasting, there has been a myth that the viewer, the listener, you and I are the consumers. We are the public being served by broadcasters. That is not true. The consumer in the broadcasting industry is the advertiser. He buys time from the broadcaster. The broadcaster provides the advertiser for money a certain number of people who will hear about his product. What happens there is that the public, the viewing and listening audience are the product. They are not the consumer. We are being sold to advertisers by means of broadcasting. The marketplace does protect the interests, usually, of consumers within a strict marketplace according to economic theory. But what we have here is the public being the product being sold. And in marketplace forces, there is nothing to protect the product. What the marketplace will protect is the advertiser's wants and needs, but not the public, because we are merely the product. And that distinction is very important to keep in mind. That is why consumer wants is not enough for the public interest.
Who's up with a question? Joan?
Mr. Nielsen, proponents of this legislation use the argument or the rationale that newspapers charge for the space that they sell. Why should an individual or an organization expect to receive free airtime? What would be your response to that?
Broadcasters have for a long time stated that they should be compared to newspapers, that they should receive the same protection, First Amendment protection, as newspapers do. But there are two basic distinctions. Newspapers are not the same as the broadcast industry. You have, on one hand, broadcasting media versus the print media. Any of us can go out and engage in expressing our view through the print media. I can make Xerox copies of something, or if I have enough money, I can start a newspaper. But none of us, even if we have the money, can start up a radio or television station unless we can receive a license from the government. And only a certain number of licenses are given out to each marketplace. So that if I am a broadcaster, I've received a license, someone else wants one, they may not be able to get it because I already have it. So I'm receiving a First Amendment right at the expense of someone else. The obligation behind that is because I've received it, I have an obligation to allow the expression of other views which do not hold a license. A broadcaster is a trustee of the airwaves. The airwaves belong to the public. He is given a right to use them for his own profit, but a certain amount of time he must give in public service. He must allow other views to be expressed. A newspaper, on the other hand, the newspaper owner owns the print, he owns the paper, he owns the ink, he owns everything about it. It is totally a closed system. He has no responsibility to anyone else because he owns everything about it. In broadcasting, that's not true. The broadcaster does not own the air and the frequency over which he travels. Every 3 years, he has to go to the commission and prove that he should have that license for another 3 years. And if he doesn't serve the public interest, they'll give it to somebody else.
Would you agree, though, that, or do you feel that newspaper publishers would agree, though, that they have no responsibility to the public?
They have an ethical responsibility to the public as journalists. There is a difference, though, between an ethical responsibility and a mandated responsibility constitutionally, which newspapers would not have. They have the freedom of press, which broadcasters do not have because of that difference that they are trustees.
The Communications Act of 1934, Mr. Nielsen, established the notion of public trusteeship, and the phrase we heard was in the public interest, convenience, and necessity, and that it was how the licensee held the license. Is that going to be changed in any way by the proposed rules and orders?
It will be completely changed. What the FCC staff is stating in their proposal is we will take the basic idea that a broadcaster is a trustee of these airwaves, that he must serve the public, the listening and viewing audience. That will be changed to having to serve consumer wants on a marketplace basis. No longer will the idea that every broadcaster, each individual broadcaster, has a responsibility to serve the public. They're saying, no, you don't have to do that anymore, as long as the whole marketplace somehow serves. If there is some news within the whole marketplace, that's fine. Each station does not have to carry news. As long as there is some type of programming to meet the needs or the wants, not even the needs, the wants of the consumer within the whole marketplace, it's okay. Each individual station can put on a tape and have nobody in the studio. It can be fully automated, throw in as many commercials as they wish during that time, and just have someone pressing the buttons, and they'll be serving consumer wants. As long as they're making a profit, obviously they're serving the consumer wants because they're making money. And that's fine as long as somebody in the whole marketplace provides news, and it doesn't matter who.
The question could be asked then. You said they could put in as many commercials as they'd want. Would the public tolerate that?
Well, the public obviously will not tolerate going from currently, it's 18 minutes of commercials are allowed per hour in radio. Now, if tomorrow we turned around and suddenly had 30 minutes of commercials per hour of radio, the public would cry out about that. But if it's a small incremental increase, the public will learn to accept it. We see that from history. Back in the early 1930s, there was approximately 1.2 minutes of commercial to 2.1 minutes of commercial time per 30 minutes of radio broadcasting. Then in 1946, the NAB came out with their code. At that time, it was 4.5 minutes of commercial time per 30 minutes. And now we find in 1980 that it's 9 minutes. It's doubled again to 9 minutes of commercial time per 30 minutes. So if we go on an incremental step, if there is no limit set, it'll be very easy for 10 years down the road to have 12, 13, 14 minutes per 30 minutes of commercial time. The public will accept it because the public feels there's nothing they can do. Broadcasting is a large entity. What can we do? We're only one individual. We're only a public. They forget that they are more in control of the airways and of the broadcasting than the broadcaster himself. They can, an individual can go to a station and say, I don't like what's going on here. You're not dealing fairly. You're presenting too many commercials. You're not following the rules. We own, the public owns these airwaves. We're just letting you use them, and you're misusing them, so we're going to say that someone else should use the airwaves because they'll do it in our public interest, and then they can go to the FCC and request that.
You seem to indicate that that this is kind of maybe just the beginning of deregulation, and that it will lead to further deregulation in areas that are perhaps even more important. I have a question in terms of equal time and the fairness doctrine. I understand this proposal doesn't affect those particular requirements, but do you feel that it will lead to some change in those requirements at a later time? And if so, do you feel that would be good or bad?
Okay, I would foresee it will necessarily have to change the fairness doctrine, which incidentally is a doctrine that when an issue of public controversy is aired, you must have a balanced viewpoint, and that you must broadcast controversial issues of public importance. The change that will be made, though not directly by the proposal, is because the definition of public interest is changed to consumer wants, and because we're changing the obligation resting with each individual broadcaster to provide service to saying the whole marketplace, which can include a number of cities, that must serve the public interest as consumer wants. The fairness doctrine, which is based on public interest, will change with the definition. So instead of an individual licensee being required to present a balanced view, he'll be able to argue in the courts that he is serving the public interest as redefined by the Commission if the marketplace provides a balanced view, so that no longer will individual stations be held under the fairness doctrine. They could argue that the whole marketplace will have to be held by it, not individual stations. Now one can say, well, what's wrong with that as long as we get balanced view across the market? Well, look at what we're looking for. A marketplace is not an individual city. It may not just be Minneapolis or St. Paul. The marketplace includes many suburbs, many cities outside of that area. So if across that whole area you have a presentation which maybe isn't heard by everyone, it's okay. It's for advertising purposes instead of the individual. And secondly, it's totally against the basis of the Communications Act, which is that the individual broadcaster is a trustee. That has been held by Congress, and the FCC has no right and no power to change a basic definition that a broadcaster, an individual broadcaster, must serve the public interest. No matter if everyone else is presenting a balanced viewpoint on the issue, if he deals with an issue and does not present a balanced view of it, he's still held liable because he is using a frequency which belongs to the public, and he cannot misuse that. And that's always forgotten. Chief Justice Berger has stated that over 5 decades, broadcasters have always forgotten that they do not own the license, they do not own the airwaves, they are merely trustees. And that has to be remembered.
Well, to follow that up, I've heard broadcasters argue that having equal time and fairness doctrine requirements, rather than encouraging robust discussions of controversial issues, it discourages discussion of those things because it makes broadcasters leery of bringing on the first person, so to speak, to talk about an issue because they feel that they'll be incumbent upon them to find another person to have the countervailing point of view. So there's less discussion rather than more discussion. Do you agree with that assessment?
That's not necessarily true, because the fairness doctrine requires that broadcasters have on the air issues of controversy and public importance. It's not a choice. If they want to, then they must present a balanced viewpoint. They must present those views, and when they do, they must do it fairly. Now, for them to argue that, well, we can't discuss these things, discussion is going to be curtailed because we can't find fairly, it's a statement, an ethical statement. Are they saying then that if you take away that requirement, we'll have more discussion, but it'll be one-sided? Because if a broadcast journalist follows the ethics of journalism, he's going to necessarily comply with the fairness doctrine. Whether it exists or not, he'll necessarily comply with it.
Mark, if I'm to understand this, if we go to the marketplace concept, what happens then to the needs, the interests of the economically disenfranchised, those, for example, who cannot vote with the bucks, as it were?
The marketplace works on the concept of a majority. Broadcasting with advertising works on the concept of a majority. We are concerned with getting the most audience. That is what the broadcaster is concerned with economically in the marketplace. So those people who are not in the majority, the minority viewpoint, the people who do not have the money that advertisers are appealing to, the people who are elderly or have no access to the money, then they have no power within the marketplace. The views of the disabled, the views of the minorities won't be expressed because it's not profitable to the broadcaster to express those views. He doesn't want a minority of the audience, he wants the majority.
We have about 8 minutes remaining.
Thank you.
The proposal also suggests the elimination of the need to maintain the program logs. Broadcasters have said that they are very rarely used, citing examples of logs being viewed once in a year, and they would like to eliminate that paperwork. Also, indicating that this reflects that needs either are being met or the public really is very apathetic about what is going on. How do you respond to that?
In the instance of program logs, it's interesting. Just a couple hours ago, I was talking to the general manager of WCCO-FM, one of the radio stations. We're talking about the program logs. The program log is a necessary instrument for broadcasters. They need it for advertising, they need it for the engineers, for the technicians, for the producers. People have to know what's going on the air. The program log is the same thing as an inventory sheet for a department store. It's a necessary part of the industry. The program log is not going to be done away with by saying you don't have to do it anymore. Broadcasters necessarily will still keep a program log. The only question then is how will they keep it and will it be open to the public? The public needs it for a fairness doctrine complaint, for equal time provisions, for looking if the broadcaster is putting on too many commercials or if he's not putting on enough local public affairs programming or not enough news. It's a necessary tool to find out if the broadcaster is indeed serving the public interest. Without that, the public would be required to tape a show or to tape a station 24 hours a day to find out what's happening. There would be no way to bring up evidence to show that they're not working in the public interest, so in a sense you'd be granting them a license ad infinitum because there'd be no evidence to bring in to show that they were not operating in public interest.
May I spin out a scenario? And let's see how it works. Under the current regulations, if I'm to understand, if I had a complaint against the station, I as an individual had a complaint regarding the expression of a certain point of view or that a certain point of view was not expressed adequately for fairness and balance, I could go to the individual station and make my complaint. I could, if that was not heard, then I could file formal complaint with the Federal Communications Commission and begin a process of hearing. Is that correct?
Correct.
Under the proposed regulations, what would happen if I had that same situation? I feel there's an unbalanced view presented. Now what do I do?
What would happen is you can go to the station and say, you've presented something that's unbalanced and I want the other viewpoint presented or the other viewpoints presented. Give me a balanced presentation of it. And the station can say, no, we really don't want to. Someone else in the marketplace can do it. We don't have the time to do it. We've presented one show, let someone else present the other show for the other side. And they could argue then that that was all right because it would be the marketplace that would have to provide a balanced view under the fairness doctrine. Your only other recourse would go to advertisers and say, we're going to economically boycott the advertisers unless you change the broadcaster's mind on this issue, so that there's not a direct accountability from public to broadcaster. It would be an indirect accountability through the advertiser. And how can you have a broadcaster who's a public trustee without any public accountability? The notion's absurd.
Are you saying that this situation, this non-responsiveness on the part of stations would occur if this set of rules are adopted or current rules are deleted or later on as a result of this rulemaking?
It would be as a result of this rulemaking. It would require further court proceedings, but because of this rulemaking, in my opinion, the basis would be laid, the legal groundwork would be laid for them to do away with the fairness doctrine on an individual basis, which would then lead to that scenario.
What is the status right now of this particular rulemaking?
This rulemaking has had comments filed on it up until March 25th, but reply comments can be filed until June 25th of this year, which means that all you have to do is send a letter or document to the FCC in Washington, D.C., stating your concerns about the issue and just say that you're filing this in response to the comments filed by the Church Federation of Greater Chicago or the National Association of Broadcasters. Of course, we have status that might bring in, not only is this in the hopper, but there are bills in Congress which are moving to do the same thing. some not only with radio but also with television. If this were to go through, it's stated the television would be the next step. The impact of that would be to take a show like this and take it off the air. The technicians, the producers, the host, everyone who's here, the cameramen, would be out of a job for this program. If deregulation were to go through for both television and radio, and talking to union people with the IBEW, other unions in broadcasting, they figure that the workforce would be cut by 25 to 50%.
Minute and a half.
There has been an appreciable decline in public service broadcasting over the period of years. Has there not?
There has been, in many respects, local programming is going out with the networks. It's much easier to take a profitable program off of the network feed and, as you can see, in prime time. You don't have local programming being put in prime time because it costs too much. The economics of broadcasting are that you're trying to put on something at the lowest possible cost with the biggest return on the dollar. That's basic economic theory. What happens under deregulation is that the broadcaster will try to increase the income, which is commercials, and decrease his expenditures. Expenditures are programming to result in maximum profit. So you will cut back on cost for programming and try to increase your commercials and therefore get the biggest profit. And this is not to say that broadcasters, the producers, the directors, they're all bad guys, they're not in public interest. The people integrally involved with broadcasting, in the most part, are concerned with the public interest. They do want to do good broadcasting. But it is in management where the concern lies. Management are not producers, they are not the creative aspect of broadcasting, they are the economic and the sales. They are concerned with the bottom line and in satisfying the shareholders, and that's where the problem lies.
Well, the opponents of this legislation do feel that, or at least some of them, that rather than to cut back on regulations, those that are existing regulations should be enforced concerning public relations or public service programming. Do you agree with that?
Yeah, we should have enforcement, but we have to look at the regulations and take out the ones that aren't working. It doesn't mean to throw them out. It means to look at it for public interest and to help the public, not to take it away from public.
I must look at the clock. This day our concern has been the deregulation of radio. And for his appearance on Concern this morning, I thank Mr. Mark Nielsen of the Church Federation of Greater Chicago. To our panelists, our thanks. Next week, divorce, too easy to obtain. Hope you have concern, that you'll join us for Concern next week, the same time, same channel.
The program Concern is moderated by WTCN Television Director of Public Affairs, Stuart A. Lindman. Concern is produced in the studios of WTCN-TV and presented in conjunction with the Minnesota Council of Churches, the Archdiocese of St. Paul and Minneapolis, and the Jewish Community Relations Council, Anti-Defamation League of Minnesota, and the Dakotas. Opinions expressed on the program were the participants. Concern is pre-recorded as a public affairs presentation of WTCN-TV, Channel 11.